This is a lecture from OpenTuition. To benefit from the lecture, you should download the free lecture notes from opentuition.com.
Okay, here we are on company names. The names of company. Where do these names come from? Have you ever thought about that? Where does a company name? Who is inspired enough to have decided this is what we're going to call our company? For instance, there's a company quoted on the UK Stock Exchange at the moment called Zilix. Who would have this thought of that? Zizix. That's the last word in the English dictionary. Zizix. I forgot even what it means, but that's never been asked in F4. Unlikely to be asked either. So here we are. Company names. The basic rule: company can have any name. A company, you know, is a person like you, like me. And well, who chose your name? Who chose your name? In some cultures, it's the case that a boy born into the family will be named after the paternal grandfather, and then the next boy will be named after the maternal grandfather, and the girl will be named after the paternal grandmother, and so on. So if you've got a family where Mike is the father and he has son 1, son 2 and son 3, and son 1 has a son, so a grandson 1, and son 2 has a grandson, and son 3 has a grandson, they will all three be called Mike. And same with the daughters, their children are called Mike, Barbara and Jeffrey, and this one's got Mike, Barbara and Jeffrey, and this one's got Mike, Barbara and Jeffrey, and this is tradition. So who chooses your name of a company? Well, it's the promoters, and often it's just a bland name. There's a list of monosyllabic words like black, white, red, green, pink, crow, and then another list of monosyllabic names, and it's just a question of mixing these names up and picking, and so you get blackthorn and redknapp and so on. You just have lists of names like that. Who chooses names? Financial training. This is interesting. It's never been asked in law, but financial training, which has now been taken over and over and over and over, is now part of Kaplan. When financial training was being established, a form was sent off to the registrar with the choice of 3 names. The form for registering, you get the choice of space for 3 choices. And the registrar rejected that form and said, no, your names are too similar, too closely resembling other companies already with similar names. So they sent back a sheet of paper with space for 10 choices. And financial training sent those off, and all 10 got rejected again by the registrar. And they sent another form with 10 more spaces, and financial training sent those off, and all those 10 were rejected by the registrar. But this time, the registrar sent a letter that said, sorry, we have to reject all those. Why not call yourselves financial training? And the directors said, yeah, the promoters, yeah, why not? That's a good name. So that's how financial training got its name. Not many people know that. And it's never been asked in F4, so not many people really care. But it's interesting, isn't it? I think so. So any name. Who chose your name? Do you know, you're sitting there, you're a female student. Do you know you could have been called Randolph? If your parents had been a little bit wicked, they could have called you a female, they could have called you Randolph. Or if you're a male student, they could have called you Jennifer. Johnny Cash, the American folk singer, he sang a song about a boy named Sue, and the father and mother had christened their baby boy. They called him Sue, which is short for Susan, and it just made sure that as the boy grew up, he was able to defend himself, because all these bigger boys and older boys would make fun of him, and you had to learn to defend yourself against that bullying. But there are restrictions with the choice of company names. Registrar may refuse to register, as they did with financial training, a name which is misleading or offensive or the same as an existing company or similar to an existing company. If it's connection with royalty or banks, but you see, registrars change from one registrar to another. So every now and then a registrar will issue what's called a practice note that says, in my view, these are names which I find offensive or misleading. Misleading as to the area of operations or the scale of operations or the availability of resources. So you couldn't, I had my own company called Michael Little and Company. I couldn't call myself Michael Little Universal because I don't have universal coverage. So misleading as to the scale of operations or the resources available or the business that you're in. Michael Little Financial Advisor. If I'm selling sweets, I couldn't have called myself that. Name may be restricted by statute. Again, this pen, why is it messing me about like this? Name may be restricted by statute. ANZAC I've used as an example. ANZAC is the acronym for the Australia and New Zealand Army Corps, 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 which is a fancy name for a body. The Australian and New Zealand Army Corps. And the Australian and New Zealand Army Corps gained something like 63 top medals for bravery in the Battle of Gallipoli in 1916, I think, maybe 1916. And so it's always associated, this acronym, the Australian and New Zealand Army Corps, ANZAC, is always associated with bravery and gallantry and valour and strength and honour. And so it would be wrong for companies to try to put the word ANZAC in their name, because it would be suggesting that they are also bravery and gallant and strong and heroic. So that's a name which is protected. There actually is a piece of legislation called ANZAC Protection of Trade Use of Word Act, I think of 1916. Name may be disallowed as a tort, the tort of passing off. I'm seeing if I can get this pen to work. The tort of passing off. And passing off is where you pretend that you're something that you're not. There is a story about a hairdresser from the south of England who emigrated to Australia and set herself up as a hairdresser in Australia. And she called herself British Hairways, Hairways, British Hairways. Well, guess who came knocking on her door saying you can't call yourself British Hairways because your name is too similar to our own name. And their name, British Airways, the only reason that they were able to protect it was because I believe it's a trademark name, so it's a breach of trademark provision. So British Airways was not allowed to this poor single girl wanting to set herself up with a small little hairdresser's business in Australia and British Airways. If you set yourself up with a name which is similar, it should be the case that you're in a similar business. There was a P7 question asked by the P7 examiner, obviously, where as an auditor, you were faced with the prospect of one of your clients, the director of one of your clients, was leaving that client company and asking your advice about setting up a company in opposition. And the company that your existing client, was called Blake's Heaven. And the director who was leaving wanted to establish herself as a company called Blake 7. And it was going to be a competing business. Well, the names are too similar. And it's a similar name, similar business, confusion likely to result. And therefore the court should not have allowed that to happen. In fact, it never actually got to court. That was a hypothetical question in paper P7. But there have been cases, where case Waring and Gillow and Gillow, or North Cheshire and Manchester Brewery and Manchester Brewery. G. Shirk of Berkeley Square, trading as Annabelle's escort agency, and G. Shirk trading as Annabelle's escort agency, and G. Shirk of Berkeley Square. And its names are too similar, and confusion likely to result. Ewing and Buttercup Margarine is an example where confusion was decided it would result. The names are too similar. They don't look similar, but Ewing had a business called Buttercup Dairy Products Limited, and Buttercup Margarine established themselves in the same area. The name Buttercup made them so similar. They were both in the business of dairy products. The court said to Buttercup Margarine, "You're going to have to change your name." The word limited or PLC shall not appear anywhere except at the end of the name. There was an F4 question in the old style F4 where you had 10 essays to write. There was a hypothetical situation set up where a locksmith called themselves Limited Locksmiths Unlimited. And it never came out in the suggested solution, but you're not allowed to use the word limited or unlimited except at the end of the word. So you can't call yourself Limited Locksmiths Unlimited because limited can only appear at the end of the name and not anywhere else. You can't call yourself Limited Edition Books, for instance. So limited or PLC or unlimited shall not appear anywhere except at the end of the company name. This tablet of mine doesn't want to help me, does it? Name change, compulsory or voluntary. It may be that you're required to change your name, or it may be that you just want to change your name. So we've got this possibility. Oh, look, my pen's working here. Compulsory or voluntary. You may be required to change by order from the registrar. And this could be the case where within 12 months the company has been by mistake registered with a name which is too similar to an existing name. The registrar didn't see. So this situation I gave you about Blake's Heaven and Lake Seven, maybe it wouldn't instantly be obvious because you're looking at it, the registrar is looking at the words rather than the sound when you're trying to register. But then when it has been registered, Blake's Heaven is going to say, whoa, 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 you can't have that. That name is too similar and confusion is likely to result. Or within 5 years, if misleading information was supplied. Notice with these, incidentally, notice with these that there's no requirement that the members or the directors or anyone involved, there's no requirement that these people have to be English or British. I did once set up a company for a Bulgarian, and I happened to be in Bulgaria, and I was doing some teaching there, and the pub owner, where I used to have an orange juice in the evening, the pub owner said, "Would you set up a company for me in the UK?" I said, "Not a problem at all." So the constitution was in English. If it hadn't been in English, it would have required a certified translation. But I set the company up for this Bulgarian publican. Within 5 years if misleading was supplied, or at any time, if the use is likely to cause harm to the public. That's a difficult one. Causing harm to the public, excuse me, it's a difficult concept. Special resolution, we've already gone through special resolutions, haven't we? The alteration of articles in the last lecture. Special resolution 7514. Copy of the resolution amended constitution to the registrar, and the registrar will issue, crucially, a new certificate of incorporation. The objects clause. We, as individuals, we can do anything we want, so long as it's legal. Some people do things even though they're not legal, but strictly, we can do anything we want, so long as it's legal. Company can. So long as it's legal, because a company is a person in law. So since 2006, the only reason to mention objects, it used to be different. It used to take me a full morning to lecture about the Memorandum of Association, and particularly the objects clause within that memorandum. 2006 changed all that. So the only reason to mention objects is restrictively. It may be that there is some restriction. A company can do anything it wants as long as it's legal. But if the Constitution says it mustn't do this, then it mustn't do this. And that was the case in the case Ashbury Railway Carriage and Iron Company and Riche. You don't need to remember the names, you don't need to remember the dates, you don't need to remember the facts or the circumstances, only the fact that if a company tries to alter its objects in such a way which contravenes the provision within those objects, or if it, let me take that again, if a company seeks to pursue an objective which is in contravention to its allowed objectives within the Constitution, then any member can object. It doesn't matter whether you're 5%, 10%, or even if you only own 1/2 of one share. If the company is trying to do something which it is not allowed to do, which is forbidden, it is restricted from doing by its Constitution, then any member may object. But the validity of a transaction entered into by a company shall not be called into question merely because it's prohibited by the Articles. And this means that a third party entering into a transaction with a company in good faith, I'll come to good faith in a minute, is not bound to inquire whether the company is allowed to enter into that by its Constitution or whether it's restricted by something within the Constitution. A third party entering into a transaction, even though it may be specifically forbidden by the Constitution, the third party can nevertheless enforce that contract against the company. And if the company suffers loss as a result, then the directors shall be personally liable to compensate the company. So here we are. It shall not be called into question on the grounds of lack of capacity, and in favour of a third party acting in good faith, it is presumed that third parties act in good faith. So it will be up to the company to demonstrate that the third party was not acting in good faith, that the third party knew that it was contravening the Constitution. That would have to be proved that the third party was acting in bad faith, because otherwise it is presumed that the third party is acting in good faith. In favour of third party acting in good faith, the power of the directors to bind the company shall be deemed to be free of any limitation under the company's Constitution. The directors apparently have the authority. Where we have a third party entering into a transaction, they're entitled to believe that the directors who are entering that transaction on behalf of the company have that authority, and that the company is acting within the company's permissible activities. There is a little bit of Latin here that you really ought to know. Ultra vires. Ultra means beyond. Vires or vires means it's Latin for power or powerful. So it's acting beyond its powers, beyond its limitations. And directors can act beyond their powers, and companies may be entered into transactions which are beyond the company's powers. But it only applies to third parties, not to members. You see, members should know what the constitution of the member's company is. Directors should know what is the extent of the permissible activities of that company. Good faith is presumed unless shown otherwise. I've already mentioned that. No requirement for the third party to make inquiries. It is presumed in that third party's favour. So third parties are protected. But the company can't sue a third party to enforce a contract, whereas a third party can sue the company to enforce an ultra vires contract.